to recall. Mr. Sandison?
Before the witness is dismissed, we would ask the hearing officer accept into the record all of the exhibits that were proffered with Mr. White's testimony, subject to your later evaluation of their weight. Make that a motion, please.
That would be 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, 12, 13, 30, 31, 48, 51, 68, and 55.
That is correct, Your Honor.
Objection.
And Mr. Sandison, I would like to give you an opportunity. Just because you stand up doesn't mean you're going to get to go to the microphone, folks. I need a break. Mr. Ching?
Clarence Ching, I understand that there's a motion by Mr. Sandison on the floor. There's a motion by Mr. Sandison to accept the exhibits and all that on the floor?
It's an offer of the exhibits.
Okay, and I objected. The reason I'm objecting is
Sir, I was going to go to everybody, if you don't mind.
Thank you, sorry.
All right, so is it Mr. Shinyama or Mr. Ng? As to the offer of the exhibits, your position, please.
Your Honor, we have no objections to the offer of the exhibits, and we would just note for the record, we did submit prior to this contested case hearing a hearing memo, equivalent to a bench memo, regarding the memo, which basically articulated the standard for the admission of evidence, including exhibits, and just kind of set forth the considerable latitude and relaxed standard that we have here. And so on those grounds, we think it is appropriate for Your Honor to accept those exhibits.
Mr. Shinyama,
Sure.
For everyone's benefit, is there a record number that everyone can look at with regard to your hearing memo?
Your Honor, I will go back to my seat and figure out the exact doc number, but it is entitled TMT International Observatory LLC's Hearing Memorandum Re Standard for Admissibility of Evidence, and it was filed October 19, 2016, and I will get the exact doc number for you, Your Honor. Mr. Fergestrom has just advised me it's 394.
Oh, thank you, Mr. Fergestrom. So if everyone can take a look at 394, then we'll have the benefit of your bench memo.
Thank you, Your Honor.
All right, thank you, Mr. Shinyama. Ms. Aluli?
Your Honor, we're going to object to the admission of the exhibits that were proffered by the University of Hawaii, with the exception of Exhibit 30, which is Mr. Perry White's CV. With respect to his CDUA, which was Exhibit 1, our position is that during the time that he was testifying, he was unable to identify some of the figures that were represented in his CDUA application. And also, when asked questions about the decommissioning plan, which is Exhibit A13, and the public access plan, he was very deferential in referring it to the authors. I guess Dr. McLaren was the author of the decommissioning plan. I understand also we would object to the EISs, as Mr. White was not the author of those reports. Those are A2, A3, A4, and A5. I believe Mr. Hayes is coming up, and he was the author of those. There's no relationship between Planning Solutions and Parsons Brinkerhoff that was established in terms of authorship, nor did Mr. White lay a foundation as to his knowledge of much of the contents of those documents, deferring them to their authors. I think even in the business records rules, when you're referring to third-party documents, you best establish some relationship and or foundation of your own reliance upon those documents and knowledge as to how they were prepared, none of which were displayed in his testimony. Your Honor, with respect also to the Cultural Resources Management Plan A11, frankly, there was a dearth of information provided in the CDUA as to, and also in the testimony as to this witness's knowledge of culture and cultural resources. That A11 was prepared by Cultural Surveys, and if they wish to have those folks come in, if it was something he relied upon in compiling his application, which seems to have been the case throughout the cross-examination when they asked him about his knowledge of some of the ethnographies conducted by Kepamali, he was unable to say maybe he had read it. He had a general working knowledge of some of these matters, but not a specific knowledge, so as to entitle the university, who frankly should know better as they deal in academia, to entitle them to have these exhibits entered in on the basis of Mr. White's testimony. And so we would object on the fact that they do not comply with the business records standard. And also if these folks, such as Mr. Hayes, are going to be available to testify, as well as Dr. McLaren, best evidence would be to have the authors of those specific exhibits here. Thank you, Judge.
All right, thank you, Ms. Aluli. May I ask you a question? I quickly glanced at document 394, which is TIO's bench memo on the relaxed rules of evidence and also admissibility of exhibits. And mostly it's going to go to weight, in my opinion. But also, I wanted to hear your thoughts on that.
You know, Judge, I read their bench memo, and I also read those are kind of older cases, and there's been a recent case. I actually have it in my file, but it was a 2014. It was written by Justice Akoba, who is someone I very much admire, and it dealt with the shoreline management, not shoreline management, but the upper reach of the wash of the waves. So I think in that instance, they applied a kind of a stricter standard in terms of not excluding evidence, but also not just like the state, you know, some of the state officials, you just can't come in here with these presumptions of authority and assume that that's, I think they have the state surveyor testifying. So there, I feel that it's really up to the hearings officer. Yes, there's a more relaxed standard. Yes, this particular board is interested in combine a testimony and custom and practice. It has to be, because it's a land and natural resources board, and these are unique concerns for this land and for Hawaii. On the other hand, you know, you have the other side of the equation, which is government, and how much are we going to black stamp or rubber stamp government. So I thought it was an interesting dichotomy or balance that I think it's called Gibbon. I can come up with the site and maybe give it to Mr. Weinhoff. He probably knows it. He probably participated in it. I think in some respects it was made me a little on edge, some of it. I have to say it wasn't a 100% awesome outcome, but I also think it was more insightful in many respects.
And I always welcome the guidance. if you don't mind providing the citation, I would like to look at the case law. At this time, based on what I have heard and seen, my inclination is to defer accepting the exhibits. Whatever standard we're going to use for everybody. And there are a number of pro se people here who wish, I think, to offer exhibits as well. So if we're going to use the same standard for everyone. My inclination is to wait until all the testimony is over and then receive all the exhibits or not receive the exhibits, whichever standard we're going to apply. So that's my inclination. I'll go through and I'll come back to the UH, but Ms. Ward, you have anything to, do you wish to say anything? I'm not going to be receiving the exhibits right now. You object to that? All right, so Ms. Peixoto? Go ahead.
I hope I'm doing this right.
Sure.
I just want to say I do think we are under the more lax system under Chapter 91-9.
Yes.
Under Chapter 91-9, we are more under the lax system. I do want to say something to the weight. If it is accepted in, then I want to say that generally there's a tendency for us to defer to the agency people and quote unquote expert people, people with CVs and things like that. But I also want to say that he could not really testify well to his own exhibit. I mean, to his own testimony and his exhibits. And so that's where some of my problem comes from, is that it needs to be weighted properly. And I do agree with what Euclid is saying as well. And that's all I needed to add in.
Are you objecting to my decision to defer receiving?
No, I think that's fine. It's just if you do let it in, I just want it to be weighted properly.
Okay, I'm not going to let it in, but if you,
Okay.
and you're not objecting to that.
I'm not.
Okay, Ms. Case?
Thank you.
Mr. Ching?
Clarence Ching. I'd like to add for the record that I concur with what Ms. Aluli presented. I adopt what she said, and I would like to join with her on her objection. Thank you.
Okay, I understand. Mr. Ferguson? Ms. Kihoy?
I have no position at this time.
Thank you. Mr. Kanuha? Aoli, no. Kamara, Mr. Kamara?
I also have no position.
Thank you. Mr. Ashida?
No objection.
Ms. Lightholm?
Lena Alice Lightholm. I don't have a position right now on that, but what I did want to say before we went on break is that I do support Billy Freitas' comments about the coaching because I've seen it and I've watched it throughout the different hearings that we've been in. So just to support him.
All right, thank you. Mr. Sinkin?
Your Honor, I do have a little bit of concern with your plan to defer until all testimony is heard, if I understood your plan correctly.
That is.
For example, I might want to object now to the fact that he repeatedly said he was unfamiliar or couldn't remember documents he referenced when writing the report back in 2010. Now he's testifying here and did not take the time to go back and look at those documents and be prepared to testify about them. That's an observation that I can make here today, but after all the testimony is over, if I stood up to make that observation, no one would have any recollection.
Would it be better if I receive these in evidence and then you can make your objections and for the record, and we just keep moving forward?
No,
Well, then
we have a problem. Okay, so if we defer, then at the time you take them up, after all the testimony, we will go through each exhibit as to whether it's to be admitted.
even what you just said to me goes to wait.
Wait.
Yes, that's what I think, but you're welcome to renew your objection at the appropriate time. I'm going to use the same standard for everybody.
Everybody, I understand that, yes.
All right.
Okay, thank you.
Thank you, Mr. Sinkin. Mr. Kanaile? All right. And when you say everybody says no objection, it's to my plan to defer. That's what I'm asking. Mr. Vicente? No position. Mr. Kealoha?
Aloha again. Kamana Kealoha here. I support would this be a motion or your decision to defer? And I just wanted to expand on some of the reasons why, if that's okay.
You want to expand on the reasons why it's a good idea to defer?
Yes.
When I've already decided to do that?
I don't know if I'm asking if that's
You can
okay.
try and talk me out of it. Go ahead.
No. To support your, I guess I support the motion, and I wanted to support it with a statement, unless you don't need it.
I don't think I need it, but you're welcome to give it if you wish.
Okay, I heard others give their opinion. I agree with the fact that White was not the author. How can we validate these documents? I wanted to expand on that by reiterating that he kept said he didn't know essential and Hawaiian cultural terms like mai kaula inaivi, kala eola naivi, lilinoi.
You need to write that out for our court reporter and then hand it to her during the noon recess, what you just said.
Oh, okay, kalamai, and I will. Mahalo for letting me know.
So if there is nothing else, we need to move forward.
There's 4 more points.
If you can summarize, please.
He could not explain, quantify, or offer any systematic, reliable process in which he weighed the value and influence of the cultural survey on the EIS and CDUA recommendation. No answer at all as to what the reasoning is that we're using a 2010 recommendation as opposed to this is 2016. Discrepancies with the references he says he relied on when he made his decision. And thank you very much.
Okay.
And I will write that down.
Ms. Freitas, did you have any objection to my deferring the exhibits? Mr. Freitas, any objection to my deferring the exhibits?
No objection.
Thank you. And Mr. Ferguson, did I ask you earlier? I seem to have. I did.
Yes, I have no objection.
All right. Thank you. I lost it. So, Mr. Ching.
Clarence Ching, just to clarify, I was objecting to Mr. Sandison's motion, and I agree with your finding.
Thank you.
Thank you.
Mr. Sandison?
We note for the record that exhibits R1, R2, R3, R4, R5, R7, and R8 are the same as our exhibits A1, A2, A3, A4, A5, A7, and A8.
Are you withdrawing the exhibits?
No, and those documents are already in the record. And we also note that we have joined in TIO's memorandum and added some additional information. That document is not yet posted in the documents library, but we, of course, defer to the hearing officer's decision, and we appreciate that the same rules will apply to everyone as far as the admission of exhibits go.
So based on what you just said, it sounds like those exhibits are cumulative.
They are in the record.
They're already part of the record, so why do I have to receive them then?
They were tied to Mr. White's testimony if you believe that it is appropriate, and I think that is something you would take into consideration as you evaluate this going forward.
All right, I'm going to continue to consider it and defer until the end of the witnesses. Mr. Shinyama, did you want to add anything else?
Your Honor, we understand what Your Honor is proposing, and given that it is a relaxed standard in these administrative proceedings, we have no objection to that plan that you have proposed, so long as obviously it's evenly applied to everyone. You know, Ms. Aluli brought up a bunch of things about business records, evidentiary rules. You know, if we're going to go down that road and be strictly in compliance with evidentiary rules, we're going to be here a long time, and I don't think a lot of people will be able to lay the proper foundation for their exhibits. And so I'm just saying it has to be an even playing field in terms of admissibility. And I understand Your Honor has already noted that, and we appreciate that. I would ask, though, for the case that Ms. Aluli referenced, if she could provide myself or everyone in this room with the legal citation.
Your request is so noted, and I think hearing you, it makes me more confident that this is the right thing to do. Wait till I see all the exhibits, hear all the testimony, and then deal with the exhibits at the end, because then I will be able to apply the same standard for everybody. So, Mr. Kealoha, you have anything else? If it's the same issue, I'm going to ask.
Well, I believe he mentioned my exhibits, R1. Am I mistaken? Through
No,
R8?
no. He's talking about the record.
Okay, thank you very much.
All right. Sorry about that. Thank you for asking. Mr. Sinkin?
Yes, I wanted to address the idea that the R exhibits are the same as admitted evidence. We had a little bit of discussion about that once before, but it's still
the
not.
record.
It was the record created at the time the case began by the parties that were admitted at that time before interventions took place.
Yes.
And so that was the record was the application and the supporting documents, if I understood what was being admitted.
The record is clearly in the document library designated R.
No, I understand that. I understand that. But what is there in that R section is the original application and the documents supporting that application. That's what was put into the record so that the case could begin.
Yes.
It couldn't begin without the application and its supporting documents.
Right.
That didn't mean those documents were submitted and validated as evidence.
Mr. Sinkin, I'm going to explain it one last time.
Okay.
So, at the time we held the first pre-hearing conference, there were only two parties. That was Mauna Kea, Anainaho, and Kahea, represented by Mr. Wardeman, and the university.
And how did they become parties? Mauna Kea, Idaho become a party?
They came back on remand from the Supreme Court.
For a new contested case?
For a new contested case. So I don't know anything about the case.
Right.
I needed to figure out where we needed to pick up. So I was relying on the representations of counsel at a recorded pre-hearing conference.
Okay.
And so it was ascertained that those are designations, whatever was there, is where I would be picking up the case from. That's the record.
Right.
So that's what happened at the first pre-hearing conference. And then subsequently, we entertained motions to join as parties.
Right.
And then we had the hearing on that. Then I set pre-hearing motions deadlines.
Right.
And then we dealt with all of those motions as well. And so that's where we are.
Okay.
There's nothing else I can add to that.
I understand. Thank you.
All right. Ms. Aluli?
Your Honor, I was not, and I have asked Mr. Wardeman about his recollection of how the R, not Mr. Kealoha's R's, came to be on the record. And I will probably go and have to ask for a copy of the recorded pre-hearing thing. Would that be through this court reporter?
Yes.
Okay. And the site is 132 Hawaii 9. It's Diamond versus Dobbin.
And could you spell the last name?
Dobbin.
And the year, please?
It was January 2014.
Thank you. All right, so we're going to get the next witness up, please.